Putting your kids on the deed to your house just to avoid probate can be one of the biggest estate planning mistakes you make. If you own your home in Connecticut and you're thinking, I'll just add my kids to the deed so the house goes to them automatically when I die, you need to understand what you're doing because that could be a big problem. And because saving your family from one court process while accidentally giving away control to your house, exposing someone else to your problems, or creating more expensive problems for your kids doesn't make sense. Hi, I'm attorney Kishore Kapoor, a residential real estate closing attorney with Connecticut Real Estate Closing Attorneys. And every day we share real life stories from real closings so you can learn from my clients' mistakes and have a smooth and hopefully stress-free closing. Today, we're talking about something a little bit different. The first thing we need to talk about is probate. What is it? It is something for some reason that scares everybody. They've heard a horror story. They've been involved in a horror story. Something went wrong. But probate is really simple. It is the process to take somebody's property that is incapable or deceased and transfer it along and to carry out their wishes. Right? It's a way of transferring property from somebody that's passed to somebody that's alive. So we hear a lot of clients trying to avoid probate. Let's put the house in a trust. Let's transfer and add the kids' names. Today, we're going to discuss why that may not be the right idea or it might be the right idea. It ultimately depends on what are you trying to accomplish. So let's get into it. I'm going to tell you 2 stories, and then I'm going to leave you with 4 or 5 lessons. Story number 1. We had a client bought a house $200,000 25 years ago. It's worth about $600,000 now. Mom, we're going to call her Jane. Jane wanted to leave her son, John, the house without having John to go through probate. She heard a horror story that probate takes years. It's a headache. She said, very easy. I'm just going to put John's name on the deed. So John's going to co-own this house with me. So when I pass, it automatically goes to him. Well, that's one option. That's option 1. And that's called transferring the property and keeping joint tenants with the rights of survivorship. So we add John to the title. Well, here's where Jane didn't think about it. John cheated on his wife. Yeah, it happens. We get it, right? Like they get divorced. And now John's ownership in Jane's house becomes part of the divorce. And John's ex-wife is angry. And I don't necessarily blame her. She's angry. She's hurt. She's mad. She says, I want half of that $600,000 house. So I want $150,000. John and his mom either had come up with $150,000 or sell the house and pay her to get off of it. Luckily, John and Jane had the money. They paid her to go away. But that is one of the biggest risks that parents don't think about when transferring the house to their kids, is their kids' problems now become part of them, their problems, right? Meaning if the kids go through a divorce, mom and dad's asset, the house, is now in jeopardy. If the son driving down the road in my house in Hamden and hits a young Yale law student and kills them, mom's house now is at jeopardy for being liened for that lawsuit because it's an asset of John's, and that family is going to go after every asset of John's to make sure that they get made whole. So one of the biggest dangers of just adding your kids to the deed is very simply that their problems become yours. Similar situation. Mom, again, let's call her Mary. Mary buys a house for $300,000. It appreciates in value for $750,000. Mary now decides she wants to just transfer the house to her kids, right? She wants to downsize. She wants, instead of selling, she wants to just give the house to her kids, right? There's another problem here, right? So before we talked with Jane, it was about the kids having ownership and it affecting their ownership is affected by their lives and their mistakes. Mary just gives her house to the kids. The problem with just giving your house to the kids is when your kids now go to sell the house, Mary bought it for $300,000 and gave it to them at $750,000. Her kids are going to now have to pay tax on from the $300,000, which we've already gone up $450,000. That could be very dangerous, right? She also gave up control of the house. So now the kids could, in theory, kick her out. Just because you want to leave your house to your kids doesn't mean the best option is to add them to the deed or just straight out give them to the house. Now, there are a couple other ways we could do this, right? There's something called a life estate. A life estate allows you to own and keep your house for the lifetime you own it. And then it transfers to your kids upon passing. There you get the increased value that's called a step up in basis, right? The basis is what the mom bought it for. Now, if she transfers a ownership interest to the kids and retains the life use, the kids get the house after probate and get that step up in basis. The downside is if let's just call her Tiffany so we have a name. If Tiffany decides to sell her house before she dies, she needs her 3 kids to sign off on the title. So now we have to coordinate with 4 people to get it signed. It causes tax issues for mom. It causes tax issues for the kids too. So that's not always the best option, but it is an option depending on what we're trying to do. We also see a lot of clients create trusts. Yes, a trust avoids probate. And I forgot to mention, all those items are ways to avoid probate. The last one is a trust. They are expensive. They're higher taxed. There's other issues that come with them too, right? You need somebody that's a trustee. You still do not get necessarily protection from a creditor of yours. And then you need somebody that's going to take over trustee after you pass. Who's going to manage it for the kids? How are we going to do it? Not to mention there is a huge upfront cost. And if you're not extremely wealthy, that upfront cost may not make sense. Not everybody needs to have a trust. Now, you talk to probate attorneys, they may give you a different opinion and they may tell you a different reason. But as a real estate perspective, it doesn't make a difference in your deed, right? You still have some of the same risks you do, but now you have the added layer of the additional cost up front and the cost of having to file things and do a tax return and whatever other paperwork you need to. So I'm attorney Kishore from Connecticut Real Estate Closing Attorneys, and at Connecticut Real Estate Closing Attorneys, we'll be happy to talk this through with you some more detail. There isn't a great way to transfer, but it depends on your goal. And we will sit down and discuss your goal with you and see what options there are. If you decide to trust, we'll refer you out to one of our partners that handles probates. If you're going to add your children to the deed or transfer it to the deed, we'll go through a process and we talk about it. But it is very dangerous just to give the deed to your house to your kids just to avoid probate. It's not a sensible option. There are other options. Consult with a professional before you do it. And like I said, at Connecticut Real Estate Closing Attorneys, we'd be happy to help you with one of these matters and recommend some great options. So I'm going to leave you with 5 lessons. Okay. Lesson number 1 is a deed changes ownership. So if you add your child to the deed, you give them legal rights to the property. It's not just simply adding a name. Additionally, if you transfer the deed to your children, you no longer own it and they could kick you out or their spouses could kick you out. Looking at probate, number 2, looking at probate as a bad thing is not necessarily, right? There are things that are there to protect you. Maybe it makes sense to just let it go through probate, right? Because it's going to cost you money either way. Maybe it will cost you less at the end, but it protects you during your lifetime. You might not even have the assets when you die. So you're worrying about it now to protect it from probate when you might spend all that money and not have it left. Understand your options is number 3. There's a will, there's trust, there's ownership structures, there's other plans that you can put in place to make the probate process easier, quicker, or avoid it altogether. But you need to understand that just adding your kid to the deed is not the only option. I would honestly say that is probably the worst option. You should start with your goal. What are you trying to accomplish? Then connect with an attorney. It could be a real estate attorney. It could be a probate attorney, probate and estate attorney. We work backwards then, right? If our goal is to avoid probate, maybe it's not transferring the house to the kids. Maybe it's a trust. Maybe it's just doing a will and go through probate because it's not that bad. And as always, I'm always going to recommend build a team. that you can contact and you can rely on when you have questions or issues. I would be happy to be part of that team, but you need to have a team in anything you're doing related to real estate. And as always, if you want to make your next real estate closing easier and close with confidence, watch this video next. I'm attorney Kishore Kapoor from Connecticut Real Estate Closing Attorneys, where we make real estate closings easy to understand.